Esteemed presenters, partners, the Caribbean Policy Consortium, and the U.W.I. St. Augustine Faculty of Law, other members of the panel, colleagues, members of the media, ladies and gentlemen, good afternoon. On behalf of the partner institutions, I am pleased to provide opening and welcome remarks at this webinar, the Guyana-Venezuela Controversy, the Argyle Declaration and Implications for International Law in the Caribbean. Collaboration across disciplines and with policy-oriented bodies demonstrates the multidisciplinary nature of our work and allow all three partners to cater and reach out to a more diverse audience and expand our outreach efforts. We are also extremely pleased to welcome our distinguished guests and audience to this event. Deepest gratitude to all our old and new friends who are here to listen and participate. It is good to have you here. The issue under discussion is an important one for regional governments, citizens, as well as the international community. So we are grateful that you have taken the time to share your expertise and insights on it. While there have been many events on this topic over the last few months, our hope is that as we focus on the international law and diplomatic dimensions of the topic and examine key areas of concern for the Caribbean, we would have shared new and innovative perspectives and added to the discussion. We look forward very much to rich, balanced, and measured presentations and discussion. Having said that, I am pleased to introduce our very distinguished panel. And it is not a cliche when I say distinguished. We have seasoned, regionally and internationally acclaimed experts who have been intimately involved in different ways on the Guyana-Venezuela situation. In the order in which they will speak, we have Mr. Carl Greenidge. Mr. Greenidge is a former Vice President of the Cooperative Republic of Guyana and is currently the advisor on borders and agent to the International Court of Justice in the case concerning the validity of the 1899 Paris Arbitral Award between Guyana and Venezuela. He has been a ministerial spokesman as well as a lead negotiator of teams that successfully negotiated commodity protocols, cooperation and development finance agreements on behalf of Guyana, CARICOM, and the African Caribbean Pacific Group of States. Prior to entering politics, he was a university lecturer and has published numerous academic articles and monographs in public finance, public sector economics, agricultural economics, science and technology, as well as debt rescheduling and management. Mr. Greenidge has held several key ministerial portfolios, such as foreign affairs, finance and planning, as well as trade. He has also served as the SGAI of the ACP Group of States in Belgium. He was director of the Technical Center for Agricultural and Rural Cooperation in the Netherlands and the director of the then Caribbean Regional Negotiating Machinery. Professor Ivlo Griffith. Professor Griffith is a fellow with the Caribbean Policy Consortium and Global Americas and a senior associate with the Center for Strategic and International Studies. A widely published Caribbean expert, his most recent book is Challenge Sovereignty, the Impact of Drugs, Crime, Terrorism, and Cyber Threats in the Caribbean, from the University of Illinois Press, 2024. He has testified before the U.S. Congress and has been a visiting scholar at security institutes in the United States, Canada, and Germany. Professor Griffith has also served as an academic leader, including as a Dean of Florida International University, Provost at universities in Virginia and New York, President of Fort Valley State University, and Vice Chancellor at the University of Guyana. He's the recipient of the Perry Award for Excellence in Security and Defense Education, named in honor of former U.S. Defense Secretary Dr. William Perry, and conferred by the Perry Center for Hemispheric Defense Studies at National Defense University. Professor Anthony Bryan. Professor Bryan is a fellow with the Caribbean Policy Consortium, professor and senior fellow with the Institute of International Relations at the University of the West Indies St. Augustine campus. Professor Bryan, who received his PhD in Latin American history from the University of Nebraska at Lincoln, is a leading scholar and consultant on energy development, energy geopolitics in the Caribbean, and regional security. He has published widely in those fields and on the topic of Caribbean regional security, with his most recent publication titled The Caribbean's Blue Economy, Is There a Future for Oil and Gas Sector?, edited by Peter Clegg et al. During his academic career, Anthony Bryan was a tenured professor at the University of Rhode Island and then at the University of the West Indies in Trinidad and Tobago, where he served as professor and longest-standing director of the Institute of International Relations. He later directed the Caribbean Studies program at the North-South Center of the University of Miami. Next, we have Dr. Alicia Elias Roberts. Dr. Elias Roberts is the Dean of the Faculty of Law at the University of the West Indies St. Augustine campus in Trinidad and Tobago. She has over 20 years experience as an international lawyer and an energy and environmental law academic and consultant. She has done consultancies for several international organizations, including the CARICOM and various governments in the Commonwealth Caribbean. She has written over 20 journal articles, chapters in books, and edited books with reputable publishers. Dr. Elias Roberts has a law degree from the University of Guyana, a Master's of Law degree from the University of Oxford, and an LLM in Energy, Environment, and National Resource Law from the University of Houston. She has a PhD focused on energy development law in distinguished disputed maritime zones from Queen's University, Canada. She's a brilliant academic, award-winning scholar, international legal consultant, and attorney at law admitted to practice in Guyana, Trinidad and Tobago, and the US. She has lectured public international law for over 20 years. And finally, in accordance with our order of presentations, we have Ambassador Riyad Insanali. Ambassador Riyad Insanali, a retired career diplomat, has served as Guyana's 8th ambassador to the United States and 4th permanent representative to the Organization of American States from September 2016 to June 2021. In a career spanning 31 years, he specialized in multilateral diplomacy, regional integration issues, and Latin American Caribbean relations. He received Guyana's 3rd highest award, the Catholics Crown of Honor, in the 2019 National Honors for Long and Distinguished Service in the field of diplomacy and international relations. Ambassador Insanali is currently a fellow at the Caribbean Policy Consortium, a non-resident fellow, senior fellow at the Caribbean Initiative of the Atlantic Council, Adrian Ash Center for Latin American, senior Caribbean advisor, Transnational Strategy Group in Washington. Among other things, he served 2 terms as a member of the board of the Institute of International Relations at UWI St. Augustine. He studied modern languages and Latin American studies and holds MA and MPhil degrees from the University of Cambridge and a PhD from Harvard University. You see what I meant when I said they are indeed distinguished. We are very honored to have all of you together on a panel. With this poll, we anticipate deep insights on this topic. The first speaker will have 15 minutes to speak, while the others are allotted 10, after which we'll have a question and answer segment. Please feel free to post your questions in the chat during and after the presentation, and they will be addressed following the last presentation. I now invite Mr. Carl Greenidge to deliver his presentation. The floor is yours, Mr. Greenidge.
Hi, Dr. Montes. Can we move on to the second presenter, please?
Thank you very much, Tanisha. So now we call on Professor Ivla Griffith to make his presentation. Professor Griffith, it's good to have you, and we look very much to hearing your presentation.
Thank you. Good evening to everyone. I'm delighted to be part of the conversation on a critical issue involving not only Guyana, the region, but as a broad international community that has important interests in this saga. You know, if you were to paint a portrait of the annals of time, you'll find that the month of December has been a significant month, a consequential month in several parts of the history of our planet Earth. For example, it was in December in 1492 that Christopher Columbus made his era in this hemisphere. It was in December in 1822 that Dom Pedro established an empire in Brazil. If you were to go to the subsequent year, 1823, it was in December of 1823 that what became known as the Monroe Doctrine was enunciated. And finally, if you were to go to 1989, it was in December that the United States invaded Panama to capture Manuel Noriega. I mentioned the month of December as a consequential month over time because for the Guyana-Venezuela saga, the month of December of 2023 also has begun to reveal itself as a consequential month. I'll tell you how the consequential manifestations have been. It was on December 1st, for example, that the ICJ, in response to a request from Guyana, announced its decisions about some provisional measures in regards to efforts by Venezuela, efforts which manifested themselves on December 3rd, not a consequential date. December 3rd, referendum. But if you were to take a look at the very month of December, you'll find there were other consequential developments after December 3rd. It was later on after the referendum, for example, that Venezuela published a new map, a map in which it announced to the world a 24th state, Guyana-Essequiba, that 24th state being the entire Essequibo territory of the Republic of Guyana, of which I'm a proud citizen. But I want to spend a minute or so, colleagues and viewers and friends, focusing on another date in December that has been consequential. That date is December 7. It was on December 7 that there was a meeting in Argyle in St. Vincent and the Grenadines that led to the development, the writing and agreement to a document that has become known as the Argyle Declaration. What is the significance of the Argyle Declaration, you may ask? And I don't have time to go into the elements of the Argyle Declaration, save and except to say that it has 9 clauses, 8 of which are substantive clauses, the rest being symbolic clauses. But I think the importance of the Argyle Declaration lies significantly in the fact that it allowed not only Guyana and Venezuela, but the region as a whole, the hemisphere as a whole, to lower the decibel of anxiety, lower the jingoistic decibel that was emanating from Caracas, enabling some amount of tension release in what would likely have been armed conflict involving an aggressive state called Venezuela. But I think it's important to recognize that there's much more to the Argyle Declaration than that lowering of jingoistic decibel. I think we saw in the evidence of the Argyle's actualization a triumph of diplomacy. We saw the triumph of diplomacy, but also as well the efforts, the worth and wisdom of a gentleman called Dr. Ralph Gonsalves, Prime Minister of St. Vincent and the Grenadines, who was able to work some political, diplomatic, personal magic in friendships in various parts of the hemisphere to bring the leaders of Guyana and Venezuela together for a conversation about how to move forward without moving forward in a conflictful way. But I think it's important in talking about the Argyle Declaration to focus not only on what the Argyle Declaration will have achieved, but to remind ourselves of some of the things that it did not achieve. It did not achieve, for example, a reversal of some of the things that Venezuela had begun to do. It did not lead to the removal of that map that showed Guyana-Essequiba as a part of Venezuela. Indeed, you had a certain amount of arrogance on the part of the president of Venezuela, who arrived in Caracas on a plane that had emblazoned on it, a map of Venezuela with Guyana's territory as part of it. So I think it's important to recognize that there are many things we can celebrate about the Argyle Declaration, but it's important to keep in mind that it also did not do very many things. The very day on which the declaration was signed, the 24th, you had the presentation in Caracas, the 2024 budget by Vice President Delcy Rodriguez. And the Vice President not only presented a budget for 2024, but significant to that budget was a component of the budget focusing on the new state. Venezuela asked its National Assembly to allocate 729 billion bolivares, about 20.5 billion US dollars, to help the state of Venezuela enable the new state to be actualized. So I think it's important to keep in mind that there are things that were accomplished, but the journey still is to be continued. Let me end by recommending that we look forward to seeing how the declaration's evolution will play out. We saw one part of the playing out, the subsequent developments coming out of the declaration on the 24th of January, 25th of January this year, a meeting in Brasilia, the joint commission that was set up in the context of the declaration. And we're anticipating a meeting of the presidents of Guyana and Venezuela in Brasilia within the next month or two. And so as we paint the portrait of how the saga unfolds, we look back to see that December 2023 was a consequential month, not only regards to the referendum, but significantly because of the Argyle Declaration. Thank you very much.
Thank you very much, Professor Griffith, for sharing with us on the topic, the Argyle Declaration and Implications. So we revert to Honorable Mr. Carl Greenidge, who will discuss navigating the Argyle Declaration dispute, current status, and future prospects. Over to you, sir.
Good afternoon, everyone. May I first of all just apologize for joining you late. We had several other things going on today, and the traffic is just unbelievable in Georgetown. So I apologize for that. Let me say that I heard Ivelaw on Ivlaw's presentations, and much of what he says I agree with. There has been a considerable number of commentaries written by observers in relation to the Argyle Declaration, and it might be useful perhaps to bear that in mind. But what I want to do is to focus not so much on going through the declaration, but looking at certain things. One, the objectives and aims of the declaration, the commitments that are captured in it, and how meaningful those are, the role of the structure of decision-making that is reflected in it, and the mechanisms for resolution, the topics for discussion, the achievements, and some concluding observations. First of all, it is clear that the objectives, and I just follow up on what Ivelaw was saying, have to do with trying to establish peace between the parties, but more importantly, the objective is to put in place a process of facilitation. I am taken by Bertie Ramcharan's piece on the legal and political perspectives of the joint Argyle Declaration, in which he emphasizes that the word facilitation, or the process of facilitation, has legal content in terms of the role and responsibilities of facilitator and presumably the obligations of those that are to be facilitated. That is an element that we must bear in mind. Of course, whilst dealing with aims and objectives, it seems to me that there are some conflicting ones there, but I wouldn't go there for the moment. Let me turn to commitments. In looking at the Argyle Declaration, a lot of Guyanese, initially in looking at it here in Georgetown, found it rather amusing, because this is a process that has been going on for a long time. We have had 51 years of dialogue with Venezuela, and there's a certain, I would almost say, a certain ignorance reflected in the suggestion that, you know, just some more dialogue is what is needed to fix what's going on. I mean, I'm not an expert in arbitration or negotiations, but you have to look at what the parties are trying to achieve on each side before you can commend the particular process. And whether dialogue is relevant arises because if one party, as Venezuela is demanding the overthrow of an international agreement and has committed itself in an international agreement to a peaceful resolution already, why is one to believe that another commitment by Venezuela in December of 2024 should be ascribed more significance than a commitment made in 1996? I refer you to the title of the Geneva Agreement and the purpose of the Geneva Agreement, which is an agreement in which the two parties commit themselves on the 17th of February and then in May to a peaceful resolution of the problem. In any of the sections, if you go through, it should be on the screen at the moment. Agreement to resolve the controversy over the frontier and so forth. This is a framework that both has objectives, which are repeated in a different way, because we're speaking of a zone of peace, repeated in a different way in the Argyle Declaration. And I'm saying to you, one, that Venezuela has already committed itself to that, and that notwithstanding, on a number of occasions, 2015, September and October of 2015, the UN Secretary General had to intervene to call upon them and encourage them to move away from the threat of force and the presence of Venezuelan forces on Guyana's boundaries. I would also say that the document commits itself, and I can go back to the elements, commits itself to respect for international law. This appears at several points in the agreement, but respect for international law also encompasses respect for treaties that have already been signed. The treaty already signed between Guyana and Venezuela, again, the Geneva Agreement makes specific reference to Article 4 to the use of not only to peaceful settlement, but also to Section 33 of the UN Charter. And Section 33 of the UN Charter speaks of judicial process within the UN. The highest judicial forum is the ICJ. And yet we have a party signing an agreement, committing itself to respect for international law, claiming that it does not respect the ICJ. And that is, in fact, reflected in the agreement. Venezuela signed an agreement that says that the matter will be referred to the ICJ. That is in 1966. In 2016, the SG sent a letter to President Maduro and to President Granger saying if the two parties participating in the Doug Newlander arrangement did not come closer, he would send the matter to the ICJ. Venezuela is committed to that process. And when he closed off that letter, there's a passage that says, if Guyana or Venezuela disagree with this, they have to write me saying that they don't want the matter to be sent to the court. Neither country wrote the SG in response to his letter. And that's a fact. We have the documents around. So when you tell Guyanese here that you're respecting international law, what are they to make of it? Which of the treaties embraced by Venezuela will they respect? Inconsistency also in terms of the membership of the membership set out by way of the agreement for resolution of a dispute under the Argyle Declaration. If you look, for example, at, and I'm sorry, I'm a bit thing on this, articles 7, 8, you will see there's a structure there, Article 8, in which, you know, you have the two presidents at the top. You have foreign ministers, which is not mentioned there. Foreign ministers will meet, report to the two presidents, and then you have a whole set of others. Some of these very entities, including the United Nations, were parties to other agreements that Venezuela committed itself, and then went to the ICJ to say it did not agree to respect the jurisdiction of the ICJ. Of course, the ICJ looked at the documents I've mentioned and concluded that that was untrue. Venezuela was committed, had committed itself, and they are going to hold them to those commitments. That is what was said. Now, in terms of the structure, therefore, I'm not seeing in this structure a framework that is going to get us around the problem that was not solved under the Geneva Agreement. The Geneva Agreement has gone through moratorium, bilateral discussions from 1966 to 1970, bilateral agreements from 2016 to 2018, bilateral discussions, sorry. And you are simply putting again bilateral discussions to resolve a problem. What is it that is new here that will enable resolution of the issue, bearing in mind what the president of Venezuela was saying, Essequibo is theirs, and therefore, therefore Guyana should have discussions to give effect to that decision. I mean, is there anything here that will help? No. What one will note of that structure is that the structure, apart from the apex, includes a number of others who are observers. Given that things are being said that are not true, are reflected in the Argyle Agreement that are not true, what is the role of these observers, some of whom have been party to issues that could be expressed differently? What is the role of these observers? So that is the issue. And bearing in mind that ALBA members have since, I believe, 1982, been beneficiaries of largesse from Venezuela, is it likely? All right, let me put that way. That is one side. But as CARICOM members, those ALBA members have also been members and embraced the commitment reflected in CARICOM heads of government declarations from 2016 and beyond, saying that Venezuela must respect both the court, or encouraging Venezuela to join the court, but to respect the sovereignty of Guyana. Indeed, in 2016, the heads caused the chairman to write to President Maduro, saying that he must respect the Caribbean's patrimony. This is in response to the decrees, beginning with Decree 1787, 1859, and so forth, in which Venezuela was laying claim not only to the territory of Guyana, but also to the territory of 7 other CARICOM countries. That makes this consideration, this configuration and structure somewhat problematic. If the same persons are on the one hand saying Guyana's sovereignty must be respected, and the same persons are in another agreement saying that they are going to be party to a decision which in effect will call upon Guyana not to insist on that, where is it that we're going to go? So whilst it is true and everybody agrees that maybe, and we're not 100% sure, maybe, and it certainly wouldn't be a war, attack by Venezuela on Guyana, maybe on the United States, has been averted. The question is, for how long? Because this arrangement, just let me remind you, and you will see this in even some of the literature on UNASUR, you can't rely upon a configuration of countries, many of which have absolutely no power of consequence, to influence a superior military force. It would seem that the emphasis in this document is upon the influence of Brazil, for example, being used to try and influence Venezuela when the two sides can't agree to restrain its forces. But what can one expect in the future when Venezuela is unable to get Guyana to agree upon the cessation of territory to Venezuela? So in terms of what has been achieved, yes, something has been achieved. What prospects are for the future, this is another matter. That is quite open. Sorry, that's been a bit breathless, but that is because I just run in. Thank you.
Thank you very much, Honorable Carl Greenidge, for sharing with us how complex this situation is and the various dimensions of the complexity of the controversy. Thank you very much. You also gave us some much needed background as we proceed with the rest of the presentation. So our next presenter is Professor Anthony Bryan, who will present on implications of the Guyana-Venezuela controversy for the Caribbean in relation to gas deals and Petro-Caribe. Over to you, Professor Bryan.
Thank you very much, Claire. Greetings, colleagues, and all of you in the viewing audience. I want to thank Ivlo and Carl for having, as it was, gone to the nitty-gritty of the issue. I am an historian, and we usually like to look at the past in order to understand how we might explain the present and the future. And this is important even as we look at 51 years, as Carl put it, of discussions with respect to this controversy. So let me start by saying, quite often I ask myself, why would Venezuela want to grab a piece of Guyana? I think it's often a strategic advantage to know what drives the actions of your opponent. And this map, I think, explains a lot. Decolonization in the Caribbean after World War II forced Venezuela to negotiate its maritime boundaries with several neighboring states, including former colonial territories. Great Britain ceded the Aves Rock to Venezuela, now called Isla de Aves or Bird Island, off of Dominica. Put this in perspective, it is a 1,200 foot in length piece of territory, 160 feet in width. It rises about 13 feet above the sea on a calm day. It is often submerged by rising tides. It is a rock which Venezuela claims as an island. And that is how it sets its maritime boundaries. Patos Island of Trinidad was also ceded to Venezuela since 1942. So the point is that since then, there have been efforts by various Venezuelan administrations to reclaim more of the nation's maritime space. You can take the map off, please. Thank you. Let me be blunt about it. Essequibo is the prize at the end of the rainbow for Venezuela. The northern coast of the Essequibo would give Venezuela an additional exit to the Atlantic Ocean. The country would gain 280 kilometers of coastline, resulting not only in an expansion of its continental platform, but also of its sea limits, its adjoining areas, and its exclusive economic zone. If the coastal band towards the Essequibo is expanded and combined with its occupation of the Isla de Aves and the Los Monjes archipelago, which is off Maracaibo in western Venezuela, the nation will have the ability to control the southern Caribbean and expand its fishing and oil and gas resource zones. So this would generate total maritime sovereignty over the Atlantic for 2.2 kilometers, customs jurisdiction for 44.4 kilometers. By any measurement, this speaks of a huge advantage for Venezuela in terms of national security and defense. The current episodes, I think, are part of this effort by Venezuela to extend its maritime space. You know, sometimes it's important to know what your enemy is thinking so that you could present strategy to counteract it. So I would say our Caribbean community should be concerned that this is not an issue that will disappear, even when the ICJ rules in Guyana's favor. Constant regional and global diplomatic efforts to secure Guyana's sovereignty now and in the foreseeable future are mandatory. I think both Carl and Ivlo may have stressed that. Let me turn now to the issue that I was asked to address, which is the implications of the current controversy for the Caribbean in relation to gas deals. The current deal that would face some obstacles is the cross-border Dragon project between Trinidad and Tobago and Venezuela. TNT needs access to more natural gas. Venezuela would be able to monetize the resource, which they have not exploited in the past. But it's not clear sailing at all. The US, which has put sanctions on Venezuela, however, agreed on December 22nd, 2023, that it would give Trinidad and Tobago an exception with a license that enables Shell and the National Gas Company of Trinidad and Tobago to produce natural gas in the Dragon field for 30 years. The United States government has indicated that it will pull back on some of its sanctions relief for Venezuela if further progress towards implementing the Barbados Agreement, which includes free elections, is not apparent. If so, the Biden administration will not renew General License 44, which has provided relief to the Venezuelan oil and gas sector. The license will expire on the 18th of April 2024. Already the US has revoked General License 43, which allowed its transactions with the Venezuelan state-owned gold mining company that the Biden administration could refrain from implementing the harshest penalties on the oil and gas sector. So what I would like to say is that in this context, it is premature to speculate as to whether the drug and gas agreement would be affected by the imposition of some sanctions. The outcome will depend really on the recommendations of the U.S. Department of the Office of Foreign Assets Controls, OFAC as it's known, of the Treasury Department, which administers and enforces economic and trade sanctions based on U.S. foreign policy and national security. The second question that was posed to me is, what are the implications with respect to PetroCaribe? In the 1990s and through the early 21st century, the PetroCaribe program of cheap oil for credit for Caribbean and Central American members of the program was an energy lifeline that helped to prevent some countries from going into economic free fall. But it also proved to be a great accelerator of debt for Caribbean countries, so that by 2015, more than 1/3 of the external debt of the CARICOM members of PetroCaribe was owed to Venezuela. Let me say that this is a forceful lesson for the region. The PetroCaribe model of regional energy cooperation was not sustainable. It was based on the primacy of Venezuelan oil, on the use of ideology as a strategy for regional cooperation. In short, PetroCaribe was not a model for the region's energy future. There is at the present time a Venezuelan effort to revive PetroCaribe, and there appears to be eager anticipation by energy importing Caribbean countries that this might be the equivalent of the second coming of Christ and a signal to begin another mendicant pilgrimage to Caracas. But we should be cautious. PetroCaribe's legacy in the Caribbean demonstrates that what we really need is a clear, holistic vision of regional energy cooperation, which would integrate our regional energy policy with trade, economic, environmental, security, and foreign policies, and broaden dialogue with producing and consuming countries alike. So as we look beyond the present to the future, it is a bit of irony that the current controversy between Venezuela and Guyana may be a harbinger of better things to come. Energy is at the heart of sustainable economic development. As the Southern Caribbean emerges as a significant player in the heart of the hydrocarbon industry, driven now by the linchpin Guyana, there is opportunity for collaborative economic strategy to move toward energy security for the region. In this context, let me point out that the collaborative energy agreements by the government of Trinidad and Tobago with Venezuela, Barbados, Grenada, Suriname, and Guyana will in the future allow for the exploration of hydrocarbon resources in the maritime boundaries shared by these countries. Finally, I think the current Venezuela-Guyana controversy will come to an impasse or maybe to an end sometime in the future. So change, as we know, in geopolitics and petropolitics, driven by governments and energy powerhouses, change can be rapid and transformative. Be prepared. Thank you.
Thank you very much, Professor Brian, and thanks to you and all the panelists for sticking to time. Thanks for highlighting how a crisis can highlight some of the gaps that exist, and of course, point the way to more sustainable solutions in the area of energy security. So we are grateful for your insights. Now we invite Dr. Alicia Elias-Roberts to present on international law, implications of the Guyana-Venezuela Controversy and the Argyle Declaration. Welcome, Dr. Elias-Roberts. Thank you very much. Over to you.
Good afternoon, everyone. I hope you can hear me clearly. All protocols being observed. I'm Dr. Alicia Elias-Roberts, Dean of the Faculty of Law here at the U.W.I. St. Augustine campus. On behalf of the Faculty of Law, let me first thank the Institute of International Relations and the Caribbean Policy Consortium for collaborating with us to host this webinar. This afternoon, I'm very pleased to participate in this webinar. You just heard the title of my presentation is on the implications of the Guyana-Venezuela Controversy and the Argyle Declaration. So in my brief presentation, and I have 10 minutes counting down, I have 4 things I want to cover. 1, a brief historical perspective on the controversy. 2, looking at the legal implications and interpretations of the role of the Secretary General of the United Nations in deciding that this case should be taken to the court, the International Court of Justice. 3, I want to look briefly at the ICJ's judgment regarding jurisdiction and the jurisdiction issues that they looked at so far. And then 4, briefly, the legal implications of the Argyle Declaration. So turning to 1, the historical perspective. We know from international law, and I did ask my students of international law to join us in this webinar, that the sanctity of treaties is very important. It's an important principle of international law. And there are several treaties in this dispute when you look at the history that would guide the International Court of Justice when it comes to its final decision on the merits of the case. But so far, the court has looked at the jurisdictional issues, and to come to the conclusion that the court had jurisdiction, it had to interpret some of the treaties, in particular the Geneva Agreement of 1966, to discuss the jurisdiction. So treaties are important in this case. In the 19th century, the United Kingdom and Venezuela had this dispute, both claiming areas comprising the area between the mouth of the Essequibo River in the east and the Orinoco River in the west. In 1890, the President of the United States had pressed both parties to submit this territorial dispute to binding arbitration. So in 1897, the United Kingdom, because Guyana was British Guyana back then, and Venezuela signed a treaty, we can call that a Washington Treaty, that would settle this dispute. So the Washington Treaty established a tribunal that would settle the dispute. There are 5 eminent jurists who were on this tribunal, and they made an award in 1899. So Article 13 of the Washington Treaty from 1897 did indicate that the decision of this tribunal would be full, final, and perfect settlement. So it would be binding upon the parties. So the award had granted the entire mouth of the Orinoco River and the land on either side to Venezuela, and it granted the area, the Essequibo area, to the United Kingdom. Initially, Venezuela was very happy with the award. In fact, one of the Venezuelan ambassadors to Britain was quoted as saying that this award did justice and shine forth to the exclusive domain over the Orinoco, which was the principal aim that they sought to achieve during this arbitration. So for several years, over 60 years, that was Venezuela's position. After the award, Venezuela and Guyana, British Guyana back then, acted upon the award, and there was a joint Anglo-Venezuelan commission that was established to demarcate the boundaries. The parties agreed upon maps delimiting the boundaries based upon that award. So the commissioners from the British and the Venezuelan commissioners produced official maps and boundaries and agreed that this is the limits, and these are final and binding treaties and agreements. However, what changed this situation and this relationship between these two states, these two neighboring states? In 1962, we can observe that Venezuela had informed the Secretary General of the United Nations about this dispute. And one of the things that they said, it was the result of political transactions carried out behind Venezuela's back, sacrificing its legitimate rights. However, on international law, these types of awards are binding, treaties are binding and final, and you need to have evidence of fraud to vitiate the agreement and make it null and void. So from 1962 to today, Venezuela has failed to provide the kind of evidence needed to vitiate that type of award. After the allegations of fraud, there was a tripartite examination with representatives from the United Kingdom, Venezuela, and the United Nations to look at where's your evidence if you're saying that this award is null and void. Where is the evidence? Venezuela failed to provide evidence. And in 1966, right before Guyana gained its independence, there's the Geneva Agreement, the one that gave the court jurisdiction. That agreement was signed on the 17th of February, 1966. So an agreement between Venezuela and the United Kingdom of Great Britain. That agreement provided various modes of dispute settlements, mixed commission that did attempt to resolve the dispute, and it was unsatisfactory. So there were mixed commissions from 1966 to 1970. There are many things that happened. There was a Port of Spain that had a moratorium in place. So from 1970 to 1981, a moratorium on the provisions on the Article 4 of the Geneva Agreement of the various modes of settlement. In 1981, Venezuela said it's going to terminate this protocol of Port of Spain. There are good officers who were appointed in the 1990s all the way until 2017. To 2014 and then in 2017 by the Secretary General. Good officers failed to resolve the dispute between the two parties. So Article 2.4 of the Geneva Agreement, this Treaty of 1966, provides that if they could not resolve the matter, the SG could refer it to the International Court of Justice. So in 2015, the Secretary General had said, you know, he's going to look into this option. In 2017 also, they said, after carefully looking at the various attempts at mediation, high-level discussions and mediations, significant progress has not been made towards arriving at a full agreement to resolve this, because you don't want to have a dispute hanging over your head and it's forever into perpetuity. There is no end in sight. So I think this was a good decision that it will go to the International Court of Justice. So Venezuela rejected this. They had said before the International Court of Justice that a court doesn't have jurisdiction based on the 1966 agreement. So what exactly is in that 1966 agreement? If you look at Article 4.2, I don't have enough time to be reading and quoting it, but you can find the agreement easily online for my students logging in, that you can see the words of the agreement that if you cannot, the means of settlement on the Article 33 of the Charter, the Secretary General could refer this matter. If you're not getting to solve it by these other means, the Secretary General could choose the other means. So the agreement gave the Secretary General the power to make a decision. So a major issue that is interesting in this case is, and the ICJ had to discuss this in their jurisdiction judgment, is whether the parties give their consent to the judicial settlement of this controversy on Article 4, Paragraph 2 of this Geneva Agreement. So what the court had said, and if you look at Paragraph 67 of the judgment on jurisdiction, is that unlike other provisions in other treaties that would leave that decision to the parties themselves, right? Because that's important. The ICJ needs consent of states to exercise jurisdiction. It's a principal judicial organ of the UN, but it's not compulsory jurisdiction. It requires the consent of states. So they had to determine if this agreement did give the consent by referring the decision to a third party, who's the Secretary General in this case. That's what you do. The parties did under that treaty. So by using rules of treaty interpretation and principles of international law, looking at the practice of the parties, that they had agreed to the good officers and different things, various modes that the SG had decided upon. Now you also are they're bound. It was binding that Article 4.2, which is quite unique, provided that the SG could refer this matter and becomes binding. So the court found that they have jurisdiction on that basis. I want to point out, though, that even they utilize this third party, the SG, the Secretary General, we know, don't have standing before the court. The court only deals with states. Only states can come ultimately before the court. So it is a decision that was referred, and then Guyana was in agreement with that. Venezuela is not, but it is binding. So it's quite interesting that only the states, it's a case that Guyana had to ultimately apply to the court. So it's a state, Guyana versus Venezuela. It's not the SG versus Venezuela, obviously. So that is a point that, you know, I like to explain to my students that while we have the SG playing this role, the parties before the court, it's an international court, would be the two states. So I don't have much time left, but the decision, Guyana requested several things because Venezuela has repeatedly violated Guyana's sovereignty and territorial integrity. But what the court said is that it will look at matters that it is limited its jurisdiction. So Guyana was requesting several things, and the court said that there are certain things that occurred after the agreement, and they don't have jurisdiction for that. So there's a limit to the court's jurisdiction. I don't have time to discuss the Argyle Declaration, except to say that, well, we heard a lot, but I think the matter is before the court, and that is the best place for the dispute to be settled, final and binding. And I will raise other issues that I wanted to discuss in the questions and comments if I'm given the opportunity. Thank you. I'm not hearing you.
Yes, my apologies. I was muted. So thank you, Dr. Elias Roberts, for getting into the details of the legal aspects of this case for us. And finally, our final presenter is Ambassador Dr. Riyad Insanali, who will present on the diplomatic dimensions or responses of the Guyana-Venezuela Controversy and the Argyle Declaration. We look forward to your presentation, Ambassador. Over to you.
Thank you, Dr. Montoute, for the introduction, and thank you for the invitation to present this evening. Good evening to everyone. Following the very erudite and informative presentations of my colleagues who have all touched on the implications of the Argyle Declaration in varying degrees, there's very little for me to add. That is, of course, the great advantage of coming last in a strong batting lineup. But as has been made clear by my colleagues, there are several perspectives that can be brought to bear on the Argyle Declaration, and I will try to bring some light to bear from my own perspective and base my presentation around three questions in the context of the diplomatic dimensions of the controversy. The first question, was the Argyle Declaration a good thing? 2, will Venezuela make good on its commitment to peace by ceasing its aggression towards Guyana? And 3, where does all this leave Guyana? With regard to the first question, there are at least 2 opposing views regarding the worth of the Argyle Declaration. First and foremost, it was an example of diplomacy at the highest level. The big picture is that it succeeded in de-escalating a very tense situation on the Guyana-Venezuela border. Or rather, it served the purpose of temporarily lowering the temperature in Caracas. Remember, there was never any need to press Guyana in this respect. But let us recall, Georgetown never escalated anything, never held a referendum about annexing its neighbor's territory, and never adopted a menacing posture on the border by massing troops there. But peace was declared. The Guyanese and Venezuelan presidents reaffirmed their commitment to the concept of Latin America and the Caribbean as a zone of peace. They also agreed to a process of bilateral talks under the aegis of CARICOM and CELAC. In addition, they agreed that any controversies between the 2 states would be resolved, I quote, in accordance with international law. The latter is, of course, puzzling, considering Venezuela's assertion of its, I quote here, its lack of consent and lack of recognition of the International Court of Justice and its jurisdiction in the border controversy, end of quote. Clearly, the Maduro regime has a rather different understanding of the international rule of law, as highlighted indeed by Carl Greenwich. The other diametrically opposed view is that notwithstanding the air of crisis prevailing in the lead-up to the St. Vincent meeting, there should have been more preparatory diplomatic work preceding the meeting. That is to say, foreign ministers and senior officials on both sides should have been entrusted with the task of meeting urgently to discuss the timing of the summit, its agenda, and the desired outcome or outcomes. Summit diplomacy to resolve a high-stakes crisis is too delicate an exercise to be left to chance and the real possibility of brinkmanship, especially in an asymmetrical situation as Guyana finds itself in vis-a-vis Venezuela. Everything points to the Argyle Declaration being drawn up on the very afternoon of the meeting. It is consequently a far from perfect accord, especially as it gives equal weight on the one hand to Maduro's December 3rd referendum aimed at a unilateral and illegal annexation of Essequibo, and on the other, Guyana's approach to the International Court of Justice as a peaceful juridical means of settling the border controversy. It is not obvious either what the return to bilateral talks now running parallel to the ICJ case will accomplish. The Guyana government has made it clear that the ICJ process is the only path towards a peaceful settlement of the controversy, while Venezuela continues to press for bilateral negotiations, seemingly to force a concession. The first meeting of foreign ministers in Brasilia last month did not reflect a meeting of minds, with both sides holding firmly to their respective positions. It did not seem that very much was achieved in substantive terms, but as they say, jaw is better than war, and at least they agreed to disagree. The second question, will Venezuela make good on its commitment to peace by ceasing its aggression towards Guyana? Perhaps, as has been suggested by some commentators, Maduro needed the Argyle Declaration to allow him to back away from the logical next step after the referendum and the declaration of Essequibo as a new Venezuelan state. That is, annexation by force. This way, he could play the statesman's card and save face at home. It should be noted, however, that Maduro has not, since Argyle, made any attempt to walk back any of his statements or actions regarding the incorporation of Essequibo into Venezuela. Indeed, he and his regime have used various pretexts to accuse Guyana of violating the Argyle Declaration. Most notably, there were howls of outrage from Caracas over the visit of a British warship, HMS Trent, to Guyana, and the visits of high-level officials from US Southcom, the Department of Defense, and the National Security Council. None of this was provocative on the part of either the British, American, or Guyanese governments. All of this should be seen in the context of Guyana's doctrine of defense diplomacy and as strong gestures of support from the UK and USA. None of this threatens Venezuela's sovereignty and territorial integrity, but it all sends a message to Venezuela that Guyana's own sovereignty and territorial integrity should be respected. Most people will probably be aware of the CSIS report that draws on satellite imagery showing the Venezuelan expansion of its military base on Ancocco Island on the border with Guyana, and the movement of missile launchers and missile boats to Port Giria on the Venezuelan Atlantic coast. CSIS believes that this is in context with what they call a strategy of compellence aimed at forcing Guyana to the negotiating table. The military buildup, coinciding with the bilateral meeting in Brasilia, does not square with Venezuela's diplomatic overtures and professions of good faith. Indeed, Guyanese Foreign Minister Hugh Todd and Foreign Secretary Robert Persaud have both called out the Venezuelans for not abiding by the Argyle Declaration. The Foreign Minister has spoken of inconsistencies in their approach, and the Foreign Secretary has expressed disappointment, but not surprise, at their, I quote, bad faith. Venezuelan opposition sources believe it is all yet another stratagem by the regime to distract public attention from the growing popularity of Maria Corina Machado and the socioeconomic crisis the country continues to experience. Be that as it may, it is a situation that is, however, still fraught with risk for Guyana and demands continued vigilance. The final question, where does all this leave Guyana? Guyana, for better or worse, remains committed to the process of dialogue agreed on in St. Vincent. Venezuela's intentions remain ambivalent, and evidently, based on Caracas's ongoing saber-rattling, the bilateral talks are no guarantee of de-escalation. The bilateral process, which has yielded no tangible results in more than 50 years, cannot reasonably be expected to resolve the border controversy. It is still better that the two sides talk, though, even if it is to stay Venezuela's hand with regard to the military option. But the bilateral talks should by no means be interpreted as a substitute for the ICJ process. Nevertheless, President Ali and President Maduro are supposed to meet in March, and both presidents will go there to resume their summit diplomacy, and it is to be hoped that that summit will be underpinned by the requisite preparatory work at both the technical and ministerial levels. Guyana, lacking in economic clout or military might, has always pursued diplomacy as its first line of defense against the Venezuelan threat to its sovereignty and territorial integrity. Guyana must therefore continue to pursue diplomacy, defense diplomacy, enhanced diplomacy, diplomacy as a complement to, but not a substitute for, the ICJ process, and now diplomacy in the context of the Argyle process, to counter the Venezuelan narrative and to strengthen strategic alliances as a deterrent to Caracas. Thank you very much.
Thank you very much, Ambassador, for your presentation. And what a rich discussion that we've had. I am happy that you have ended your presentation with the options for Guyana, because I want to go straight into the questions. You provided the way forward for Guyana in this dispute. But I would like to hear, as somebody has posed a particular question, what the other panelists think about what the policy, what the options are considering this long-standing controversy. So the first question, and you may answer in order of your presentation, and Ambassador Stenali, you may not necessarily answer because you have dealt with that question. It's from Mr. Roger Ali, who says that Argyle is a fait accompli. Guyana has been hoodwinked. Paragraph 1 of the Argyle Agreement hamstrings Guyana to take defensive action. Any measure taken to fortify the border will be interpreted as a threat. This will give Venezuela the pretext to attack. Paragraph 2 of the declaration undercuts the ICJ process. Where do we go from here? What are the options for Guyana? So beginning with Honorable Greenidge, we'll go in the order of speakers to comment on this first question. You're muted.
Many thanks, Madam Chair. The answer to the question will depend on whether you have an insight into whether Venezuela really intended to attack Guyana. Now, let me say that this is complicated. Yes, it is quite conceivable and still conceivable that Venezuela could send troops across the border at several points. But is it conceivable, even in Mr. Maduro's wildest dreams, that he would, with the missile vessels he has, attack American properties such as the rigs? So there is some basis for doubting whether the threat of attack could have been serious. And one has to have some sympathy for a suggestion that says that Guyana's defense reaction may be used as a pretext. We certainly saw this in relation to the British vessel, the British warships, and the visits. I mean, we've come to a situation where a vessel visits Barbados, it doesn't pose a problem. Before December, it visits Guyana, it doesn't pose a problem. And in January, it visits Guyana, and it suddenly becomes a threat to Venezuela. Something has to be wrong. After Argyle, you suddenly have no sovereign rights. You know, I mean, you're saying you have no right to allow an American to visit Guyana. Does that mean that before inviting or accepting such a request to enter Guyana, Guyana must go to Venezuela, or these members of the working group, in order to get clearance? There are a number of things like this associated with the agreement. If, for example, a new complaint is generated by Venezuela, it has to be dealt with by the group. Guyana has to answer. And this exercise can go on forever. You know, you can raise an issue, Guyana says no, it goes back to the group, bearing in mind also that that group is largely composed of allies of Venezuela. There is no, the allies of Guyana at the moment are ACP Group, US, and the UK. And it seems from the pronouncement both of Brazil and Prime Minister Gonzalez that Guyana now, in their interpretation of the Geneva Agreement, of the Argyle Agreement, is that it has no right to allow people that Venezuela regards as somehow enemies to enter Guyanese territory. So immigration office now is to be found in Georgetown and Caracas. That's my reaction to the question that you pose.
Thank you. Professor Griffith?
I want to offer two. Thank you much, Dr. Mantu. I want to offer two brief comments. I see zero option except the ICJ for Guyana. I think the reality is that the Argyle Declaration perhaps may be considered a useful, considered a necessary, but it is surely not a sufficient way to resolve the controversy. I did a fairly comprehensive analysis of the controversy published by Global Americans last December. And in the critique of the Argyle Declaration, I made an observation which dovetails with something that Ambassador Riyad Internali said. And the reference I'm making to what Riyad said has to do with the injudiciousness of having a presidential summit without a preparatory tension before the summit. If you look at clause 9 of the Argyle Declaration, when I looked at it, I was struck by what Guyana accepted in that clause. Guyana signed on to define the controversy as a dispute. For decades, Guyana has been saying this is no dispute. It's a controversy over the allegation about the 1899 award. But it sits down in Argyle and accepts a document that says it's a dispute. I think had there been appropriate preliminary discussions before sitting in Argyle, one of Guyana's team members would have recognized that this is not something that Guyana should have signed. Acknowledge that you've got a dispute. But let me go to my second comment. I still view the efforts by Maduro and the regime as blustering, militarily and politically. But I think the calculus of risk and reward suggests that it would not be in Venezuela's interests, would not be in Maduro's interests to risk pushing the envelope of aggression physically with an annexation. We don't have time to discuss the reasons, but I think there are sufficient negatives in that regard, some having to do with broader geopolitical, geoeconomic, than positives for Venezuela to do that. And I'll just mention one. I think it's clearly the reality that it is not in Brazil's interests. It's not in Brazil's self-interest to allow any annexation to happen physically. It would create a Pandora's box of Brazil. Remember that Brazil has a border with every South American country except Chile and Ecuador. And there are many apprehensions about borders with Brazil. But imagine the Pandora's box that would be open if Brazil were to say, okay, especially if Brazil were to accede, which so far, thankfully, it has not done, using a Roraima state to access Guyana. So I'm fairly comforted in the fact that I don't see a physical aggression happening. Mm-hmm. I see lots of games politically, both domestically and internationally by Venezuela. But I think there is no option but the ICJ option. And then, even after you have, I think Tony Bryan referred to this, I've said that whatever the outcome of the ICJ, the dispute will be resolved, the controversy will be resolved, because the realities of the domestic environment in Venezuela and realities of Maduro's presence or absence are very important variables in making that final calculus. I'll end there.
Thank you very much, Prof, for your insights. Professor Brian, would you like to weigh in on this question?
Yes, I would. Simply to say that, as I've said time and time again before on other webinars, there will be no war. There will be no invasion. It is a risk that Venezuela will not take because it would change the geopolitical and the military status as it now stands in South America. This is a very big issue if they were to do it. But what there might be, and I think Carl Greenwich alluded to that, is that there might be skirmishes. There might be border skirmishes, and you deal with those as they come along. But I don't think that Guyana has any option other than the ICJ, okay? But as I have said before, Argyle is a temporary damper on the issue. But we should be concerned that this is not an issue that will disappear even when the ICJ rules in Guyana's favor. So I want to re-emphasize the point made, I think, by Rhiannon Sinali and others, that Guyana's sovereignty now and in the foreseeable future, diplomatic efforts to secure that sovereignty are mandatory, and they have to be accelerated. That's the way I see it. Thank you.
Thank you, Prof, for sharing your views on this particular question. Dr. Elias Roberts, would you like to share on this question? What are the options for Guyana?
Yes, can you hear me?
Yes, we can.
Yes, I just have a few things to add. The Argyle Declaration attempted to maintain the Caribbean as a zone of peace, which I think is important. That was stipulated. Professor Griffith just mentioned that the declaration used the term dispute rather than controversy. And I know a lot of persons have commented on this controversy versus dispute. And my own opinion on that is that I believe for many years this was just a political controversy and it hadn't risen to the level of a dispute. So after 1966, I would agree it was just like a political controversy. But by taking it to the International Court of Justice, my opinion is that it is now a dispute, and that is a legal position also, because the International Court of Justice would only entertain legal disputes. So you cannot go to the court and ask them to look at a controversy. There have been cases in which they looked at controversies versus disputes and say they'll only entertain legal disputes. So Guyana had to concede that to get the court to exercise its jurisdiction. So you couldn't blow both hot and cold and continue to say it's a controversy and ask the court to exercise jurisdiction concerning the arbitral award from 1899. So we had to concede that we know this has risen to the level of a legal dispute that is before this court. The declaration as it is, while we have this matter that is pending, we have to be very careful, because what are the implications that will having agreements outside of the court? You go to the court, which is a win, you've won the jurisdiction. Venezuela attempted to have the matter, dismissed, trying various means of arguing jurisdiction and then preliminary objections. The court rejected their preliminary objections because Venezuela was saying that the UK needs to give their consent because they're party to that 1966 agreement. So Venezuela's attempted again to not have this matter decided before the highest judicial organ of the UN to come down with a final binding case. And what I didn't get to say in my conclusion earlier in my presentation is that I think international law is on Guyana's side. So it is highly likely that when it comes to the merits of the case, the court will find, based on the interpretations of international law principles, treaty interpretation, and so on, that Guyana has sovereignty over the Essequibo. And then right before the Argyle Declaration, Venezuela had a referendum that some of the panelists talked about. And there was provisional measures that the court handed down, saying that Venezuela shouldn't do anything to act upon these things that it declared in the referendum, because that would violate Guyana's territorial sovereignty, and an area that is before the court in dispute. You shouldn't go against international law to do that. So going forward, I see a question there whether this Argyle Declaration would undercut the ICJ's process. If Guyana stays true to the ICJ, it cannot. And then whether Venezuela could use as a pretext for incursion, they might try to do that. I wouldn't put it past Venezuela, because they can say that if it's a zone of peace, then it's disputed territory. And why do you have warships in this zone of peace that could lead to different interpretations of some kind of, so it's diplomatically could mean different things. And we have to be careful. So those are my comments. Thank you.
Thank you very much, Dean Elias Roberts, for this. Many of you spoke about geopolitics. Some of the panelists spoke about geoeconomics. And so there is a question on that, which says, prior to 2015, Venezuela and Guyana maintained good relations over this issue, bolstered by the 1966 Geneva Agreement and the 1970 Port of Spain Agreement, etc. Why did Guyana approach the ICJ? Wasn't that a unilateral action and as such a violation, which Dr. Roberts already discussed? So you may not want, the panelists may not want to discuss that in detail, but they may wish to say something briefly about it. The part I think that that has possibly not been touched on that I will ask the speakers to weigh in on is, and what influence did ExxonMobil have in these issues? Grateful for your responses, please.
Let me, if we're going in the same thing as before, let me first of all say to you, and I answer this because I believe it needs to be refuted very strongly. The idea that Guyana and Venezuela had no problems before 2016 is nonsense. Okay, that is not true. Even if you look 2013, the Techniques Perdana was seized by Venezuelan vessels and carried off to Margarita, and a lot of confusion surrounded that. The reason why Guyana went to the court is very clear. And let me correct some things that were said earlier. It was not the Secretary General who decided to do anything in 2015. In 2014, the Minister of Foreign Affairs of Guyana told the Secretary General that Guyana was dissatisfied with the good offices process, which had gone on from 1990 and had only served, as happens in a lot of international issues. Venezuela invaded Ancoco. Nobody acted, but everybody criticized them, but they just sit on it. And that continues up to today. And so what Guyana was saying is, look, these things are likely to get worse, because right now, once the discovery of oil was made, Venezuela started to move vessels and people to Guyana's borders. So the minister went, signaled to the UN Secretary General that we wanted him to choose another option. That was a decision taken. Then when the coalition came to office, I wrote the Secretary General. The Secretary General called the two presidents and told the two presidents, you cannot decide that an arbitral award is null and void unilaterally, okay? One party, especially the party that has received benefits, can't say it is null and void, but they're holding on to the benefits. And that is what you have. So the SG told them it has to be resolved, but before we resolve it, let us have another year of dialogue. Does that sound familiar? Another year of dialogue. Another year of dialogue turned into 2 years of dialogue because Venezuela refused to accept any new good officer that was nominated by the Secretary General. Eventually, the two Secretaries General, incoming and outgoing, decided to bypass that problem by appointing, without Venezuela's concurrence, Doug Newlander, who they could not refuse to accept because Newlander had worked with Venezuela on the Colombia problem. So you then had a process that the SG wrote to these two people saying, we are entering enhanced mediation. Enhanced mediation ran from the end of 2015 to the end of 2017. So at the end of the enhanced mediation, the letter which the SG had sent at the beginning, which was termed the way forward, explained what would happen under enhanced mediation. And if Doug Newlander could not show that the two countries were coming closer together, he would send the matter to the ICJ. When it went to the ICJ, how it went to the ICJ would depend. Venezuela alone could ask the ICJ to make a judgment on the matter. Guyana alone could make a judgment, or the two countries together could put the matter to the ICJ. Venezuela decided they didn't want to go to the ICJ, and so Guyana sent the matter to the ICJ in keeping with the SG's recommendation. I want that to be very clear because I am tired of hearing people simply reproduce Venezuela propaganda. There was nothing unilateral about this. It was part of a process that Venezuela was part of. And so that was how we arrived at the court, and I hope that your questioner listens. But let me also say, because this is related, there were a number of processes before enhanced mediation. So you had a mixed commission. The mixed commission was bilateral, okay? You had the moratorium, and that moratorium, again, arose triggered by Prime Minister Eric Williams because of the threat of force by Venezuela. When Guyana became independent, the mixed commission met. Venezuela could not force Guyana to simply admit to accept the handing over Essequibo, which was not examined separately by the arbitration panel. Venezuela was threatening invasion, and consequently, the decision was taken to try and persuade Venezuela to have a moratorium. And there was a moratorium. That's how it came about. And subsequent to that, and I make this point because people speak and forget, 2016 to 2018 was a process of enhanced mediation joined by Venezuela. Myself and the Venezuelan minister were party to that. There was a process of mediation. The question is, at the end of that process, if the two parties don't come together, this is what the SG will do. He told them, and they accepted that. Venezuela, up to that point, somehow thought it could win that exercise. When it discovered it couldn't win it, it then refused to go further and then made all these allegations about the ultra-virus decision of the Secretary General. It wasn't one Secretary General who made that decision. Both Secretaries General were involved, and it was done on the basis of a recommendation from a man very close to Venezuela. Doug Newlander was present in Barbados when Venezuela had the opposition attending a meeting, and at that meeting claiming that Guyana had not participated in any dialogue to resolve the problem with them. So we must not forget the history. It's very, very important.
Thank you for that. That was enlightening.
I want to add to what.
Yes, Professor Griffith, we look forward to your perspective on this. Please proceed.
Thank you. I want to supplement what Carl said by offering a comment and then a recommendation for reading by the person who asked the question, and others may be interested. Not only is it incorrect to say that all was well between Guyana and Venezuela until 2015 when it all was discovered, history suggests that it was just 5 months after Guyana's independence that Venezuela started to act up against Guyana. There's a thing called the Rupununi Uprising. It was Venezuela that was instigating indigenous Guyanese in the Rupununi part of Guyana to create a discontent that would allow them to ask for the protection of, allow Venezuela come in. I did a 3-part series last year for All Now magazine, online magazine. The series was called Oil and Bullyism. And I spent a considerable amount of time documenting the evidence of Venezuela's bullying of Guyana going back to the 1960s. And I want to recommend to the person who asked the question and others may be interested in, if you're not interested in reading that 3-part series, go and look for Guyana's document in 2018 when it formally approached the ICJ. Guyana laid out very meticulously the evidence of Venezuela's intimidation over many decades. Now, it may not have made the news consistently, significant cases outside of Georgetown, but the evidence is there. It was not all hunky-dory and peace on the border and peace between the two nations. Guyana was being peaceful, Venezuela was not. So look at the ICJ, Guyana's petition to the ICJ of 2018. If you're interested in read the Oil and Bullyism series, and you'll see copious evidence of how Venezuela has been acting over several decades, militarily, politically, economically, to undermine what Guyana was doing, not only in the Essequibo part of Guyana, but in the broader part of the nation's pursuit of economic development.
Thank you very much, Prof. Very useful. Professor Brian?
Yeah, I'm not sure. Are we dealing with the issue of whether Exxon promoted the war? Is that what you're asking?
The person is asking what role they have played in this whole situation.
All right, just a clarification. I do not think that the international oil companies have any role in stirring up trouble between Guyana and Venezuela. If you look at Exxon and the others, the Stabroek field is one of the most profitable fields ever discovered in petroleum engineering. And certainly Guyana has many friends that support its position. The other thing to remember, having said that, is that the interest of the companies, the oil companies, is in oil production, regardless of which nation it belongs to. So, blaming the oil companies, I think, seems useless. It pays to remember, as I've said time and time again, that the companies, like nation states, do not have friends, they have interests. And the interest of Exxon at the moment is in Guyana. In fact, it has decided to commence with drilling off the Essequibo region. That can be a tinderbox, but I don't think Venezuela is going to do anything about it. All right. So I think the spectacular success of ExxonMobil and Total Energies does provide some animosity on the part of Maduro. It's always difficult to understand why, because Venezuela already has the largest oil reserves on the planet. So perhaps in some ways it's just convenient to blame the companies.
Thank you very much, Prof. Again, very insightful perspective on this issue. Dr. Elias Roberts, would you like to add?
Yes, I'd like to add. Thank you. Right, so I see the question had several parts. It asks, or it makes a statement alleging that prior to 2015, Venezuela and Guyana had good relations over this issue. But as you heard from several of the panelists, that there was a dispute for several years prior to 2015. So I wouldn't say that they were hunky-dory and good friendly relations, but rather there was a dispute even prior to 2015, and there were attempts to settle it and mediate it, good officers and so on, to bring an end to that dispute. The question also continues, why did Guyana approach the ICJ? So I would think one of the principal reasons would be to get a judicial settlement of a dispute that would be final and binding and respected. So I see, no, but why the Guyana? Many reasons. And also if you look at the application that Guyana made before the court, you see many things outlined what Guyana was hoping the court will see in its judgment. Many reasons why Guyana approached the court. Now it's also asking, was not a unilateral action and as such a violation? It is not a unilateral action, because to go to the court, you need both states. And through the 1966 Geneva Agreement on international law, the consent of Venezuela to that agreement gave the Secretary General the right to make the decision that this is one mode by which the dispute could be settled. So in 1966, Article 4.2, paragraph 2 of that agreement provide that mode of dispute settlement, and the court has exercised its jurisdiction. So the question also asks, what influence did Exxon have in these issues? The influence of Exxon, I agree with the panelists that this is an economic interest, and the company is interested in its bottom line dollars. But in terms of international law, there are many dynamics to the issue between Guyana and Venezuela. What I will say is that after there was the pronouncement that there is a finding of oil in 2015 by Exxon, and the Guyana government saying, okay, we have this company operating offshore that have found oil in commercial quantities, it escalated the matter to a certain extent that Venezuela then issued a presidential decree saying that that is within their area. So Venezuela reacted to the announcement of oil in commercial quantities in 2015. I'm not going to ignore that. That happened as a matter of fact. So that took on a political dimension. Even CARICOM had to say this presidential decree by Venezuela was violating other CARICOM states' maritime areas. This claim by Venezuela. So it did play some role in terms of the reaction of Venezuela. But in terms of what is before the court, I don't see it having much in terms of the merits and the ultimate decision in terms of whether the 1899 arbitral decision is final and binding and so on. That wouldn't have any implications on that. Thank you.
Thank you very much for reinforcing the views and further shedding light on that question. Ambassador Nsinali?
Thanks, Anita. I have nothing to add. In the interest of taking other questions, I will defer. I think my colleagues have dealt quite fully with the question. Thanks.
Thank you very much. Exactly. All right. So there is another question which leans towards geopolitics and so, but I think I will I'll come back to that and ask a question from someone who wants to know the wider implications, because one of the presentations looked at the impact on gas deals, Petro-Caribbean, but a person wants to know, and of course, it has been made clear by some of the panelists that there will be no war. But if you can comment on what you think the implications are for the Caribbean in terms of their response, and even if there is no war, what implications, impact that could be having on the wider region in terms of regional integration, whatever it is that you think may have any sort of impact or outcome for the Caribbean, the wider Caribbean, beyond economics and gas deals and so. We would be happy to hear your responses on that one. And we can go, we can follow the order. If you have a response on that, you proceed, and we will go in the order. I won't be calling or pointing you out. Just let's go in the order on this particular question.
Madam Chair, might I just say, I don't really want to say very much on this, but I wanted to say that when you look at this issue of the implication of the Caribbean, you might want to bear in mind Eric Williams's comment about Venezuela's intentions in the region. Actually, I have before me the paper that he presented to the party conference entitled Venezuela Threat to Caribbean Communities, a speech he gave. It's about 9 pages. And there's a section of it devoted to the threat to the Caribbean community. And in the document itself, he examines the implications of Venezuela's attempts to conclude bilateral arrangements with these Caribbean countries. And I think most people, and certainly Anthony Bryan would probably have a far better grip on that than I, but I'm sure people have read it. I just want to make mention of that, just so we don't forget. And to tie to that, this observation, when Tony made a presentation, why would Venezuela want Essequibo? Let me just say to you that if you travel along the Essequibo River to its southern extreme, you will be within 5 or 10 miles of the border with Suriname. And this control of the Essequibo, first of all, gives you control of Guyana, because it is via the Essequibo that you can access all these areas, south and southwest, southeast of Guyana. And it puts now Venezuela in close physical touch with Suriname, and therefore in a position to have a strategic handle on Suriname. I mean, there are others here, again, who deal with these matters as a routine, but just following the river, it is clear. I would say to you also, don't rule it out as being outlandish. The rigs currently operated by Exxon and Company lie less than 100 miles, far less than 100 miles from the border with Suriname. We are facing a neighbor that is fighting us down for oil resources that are 1,000 miles from Caracas, 1,000 kilometers from Caracas, a few miles from Suriname. Venezuela has an interest, and that is one of the reasons why they're so driven by this exercise. And as I say, if you look at what Eric Williams had to say, you cannot deny that the nest of negotiations that went on after the war, and subsequently by Venezuela in respect of getting access to whether they're uninhabitable islands or pieces of coast or EZs, they have, as Tony was saying, implications for Venezuela's physical control of these areas. They're afraid on the one side of people in the Eastern Caribbean letting in, whether it is Cubans, maybe they're not worried about Cubans anymore, but in the past, Russians and other guerrilla groups. This was the obsession in 1962 that could be based in the Caribbean coast and in the Eastern Caribbean islands and pose a threat to Venezuela. That was how the US came to persuade them to lay claim to Essequibo as such, because this was not the preoccupation as was observed earlier. The preoccupation was with Orinoco, one of the richest of the maritime routes in the estuary. And also, just to add a random piece, that is the movement of people after the 1899 decision was of British settlers out of the mouth of the Orinoco River. And the Barima Point, which was given to Venezuela, enabled Venezuela to have total control of the Orinoco and Guyana to have none, so that Guyana no longer could pose a threat to activities in the Orinoco, because Venezuela was given control of the strategic point that controlled entry into the Orinoco. Thanks.
Thank you. Prof, would you like to say something on
Sure.
that?
A couple of quick points. I think it's important for us to remind ourselves, although the reference in the media and the general conversation about oil in Guyana tends to revolve around ExxonMobil, ExxonMobil is not the only operator of significance in Guyana's oil pursuits. Ironically, one of the original 2015 operators, Hess, has been bought out by a major operator in Venezuela itself, Chevron. But it is not only American companies that have stake in Guyana's oil and in Venezuelan oil. Chinese interests also are there. So the implications, if you focus only on the oil, have to do with geoeconomics and geopolitics of a variety of countries that have an interest in the oil sector. But let's remind ourselves that the value of the Essequibo is not only in relation to the oil onshore and offshore that's there. Part of the historians who are viewing or who are part of the panel might recall that even before 1841 with the dispute, the British controversy, Venezuela-British controversy, had to do with the discovery of gold in a certain part of South America. This Essequibo area of Guyana, gold is there, bauxite is there. There is uranium in their lands in the Essequibo. Then President of Guyana, Barra Jagdeo, made a trip to Iran when he was president, met with President Ahmadinejad. Why? Iran was interested in exploring Guyana's uranium. President Jagdeo even signed an agreement, but there was no follow-up for a variety of reasons, which I don't want to get into here. So I think it's important to recognize that although the conversation tends to revolve around oil interests, Guyana's Essequibo has much more than oil. Let me end by coming back to something that Carl mentioned, apropos Trinidad Prime Minister Eric Williams is concerned. Prime Minister Eric Williams was not only concerned about Venezuela to the point of writing that 9-page, he convened a special convention of the PNM in 1975 to focus the party's attention on what he called Venezuelan imperium. And he used his academic skills as an historian to lay out over many decades what Venezuela's intent and designs and pursuits were. And it's a document that is publicly available. It's worth reading to get a sense of what there has been a longer gestation of interest in the part of Venezuela, of exercising control, geopolitical, geoeconomic control.
Thank you,
I'll
Prof.
stop here.
Thank you very much, Prof. I think this is really unmasking issues that were covered and really bringing new light and shedding new light on some new issues. That brings us, in the interest of time, I'm not going to, we don't have time to ask the other panelists the insights, to share the insights on that particular question. But what I want to do before we move to the vote of thanks, there is a related question. I'll read the two last questions that we will address, and then if one person or two persons want to comment briefly on it, we will do that rather than having every single panelist address these two questions, and then we will move to the vote of thanks so that we can end at 7 o'clock. So I think a follow-up question, a related question to what has been discussed here in that segment is Venezuela then attempting to reinvent itself as a geopolitical and security actor in Latin America and the Caribbean? And then there is the other question is, should Guyana be wary of the intentions of some of its allies, particularly the US and the UK? So any takers, just one person, two persons, however you feel led to comment on one or both of those questions before we move to the vote of thanks.
Yes, I would. Let me put it this way, that Eric Williams, in his wisdom, and I remember it very well. In fact, I've written about it again in a book to be published by Ivor Griffith, I think in June. This issue of Venezuelan imperialism was a very real issue at the time. What happened, and just to be brief about it, is that Trinidad and Tobago had always seen itself as the petroleum giant within the region. It had carved a certain relationship with Jamaica and with Guyana over the production of bauxite, and that bauxite to be as it were, refined in both of those countries. And Jamaica decided to go ahead and do its own deal with Venezuela and with Mexico. It was the JAVEX or JAMEX arrangement at the time. To cut a long story short, what Williams was concerned about and railed against was the fact that CARICOM or CARISTA at the time was being fragmented. That in fact, the Venezuelans were playing off Caribbean states against each other. And he didn't particularly like that. And he, as an historian, saw it as imperialism of a new order. Perhaps he was absolutely right. I don't think that Venezuela is trying to bring back imperialism as such, but it certainly is appearing to fragment the region once again. Thank you.
Can I just say, because I don't want to extend it, the fragmentation does not extend to ALBA members.
Yeah, quite.
Okay, so that's the story, because in the context of this issue, he's brought them in en masse and excluded by his constant railing against third parties. You brought in CELAC. Was CELAC ever an integral part of the resolution of this crisis? No. The general experience with Latin America has been that Latin America has tended to be sympathetic to Venezuela's claim, primarily influenced by the problems of and the experience with the United States and Mexico, to mention just one. It is not the only one. There are many others. So this I would say to you, you are right. And in fact, the experience, the recent experience, is different from our experience with Cuba.
Mhm.
Cuba is a Latin American state larger than the rest of the region in terms of population and weight, of course, except for Haiti, but willing to collaborate with us. But you don't see the sort of bullyism in Cuba relations with the rest of the Caribbean as you see in relation to Venezuela, and the use of resources by Venezuela and Mexico when they're talking to each other to get the Caribbean to do what Venezuela wants. That's what you should also.
If I might just jump in with a final comment. I know we're running out of time, but to turn on its head an unfortunate term, that is that of, the Caribbean or Latin America, and the Caribbean being the backyard of the hemispheric hegemon. Venezuela has always seen the Caribbean as its front yard. This is not a new idea that they're reinventing themselves for geopolitical influence. They are looking to extend it, albeit under a different dispensation, the so-called Bolivarian dispensation. And we should remember that before Chavez and Maduro, Venezuela had one of the most sophisticated diplomatic corps in Latin America. And they have extended their reach in our region by having embassies in each country. And whilst some might say they're not as sophisticated as they were, they do have reach, they do have influence. And our CARICOM brothers and sisters need to be alert to the blandishments being offered by Caracas. And call me an idealistic regionalist, but I still believe that we in CARICOM need to stand together, because we are so small. If we get picked off, we will fall apart. And this is not just about Guyana and our territorial integrity. As Carl Greenwich pointed out, the Venezuelan decrees that appropriate Guyanese waters are not just about Guyanese waters. They're about the waters of 5 or 7 other CARICOM countries. It's the thin end of the wedge, and it calls for CARICOM to be very sophisticated in its thinking and to maintain unity, not out of blue-eyed idealism, but out of real geopolitical considerations.
Yeah, I just simply want to put a cap on that because Riyadh, you're absolutely right. The thing about it is that, as a Trinidadian, you can feel this pressure in many, many ways. I was in the Casa Amarilla in Venezuela when there was an attempted military coup in Trinidad in 1970. And a Venezuelan admiral approached me and he said something that has always stuck with me. His intimation was that they would not let anything happen to Trinidad that they did not approve of. And he summarized it in the following way. He said, Trinidad is nuestra. Trinidad is ours. Extend that throughout the Caribbean.
Wow, this was rich. It was enlightening. It was powerful. I am sorry that we have to end this, but all good things must come to an end, unfortunately. I just want to thank you so much. I learned so much, and I know our audience did. So on that note, I have to bring this very good discussion to an end. See you again on the 22nd of March, where we will be having a seminar on AI, threats and opportunities for the Caribbean. Stay tuned for more details. Bye-bye, everyone, and thank you.
Thank
Bye.
you, Anita.
Bye. Thank you.